Yes.
Yes, sir.
Mr. Belvoir, I have an address of general delivery in Longview. Is that where you get your mail?
Yes, it is, sir.
You're here in our jail on new criminal charges dating, looks like from the early hours of this morning.
Yeah, 4 o'clock.
This is a charge. There are 2 charges here: resisting arrest and disorderly conduct. The maximum penalty for the most serious of these, the resisting arrest.
Hey, can I tell you something, sir?
Just a minute.
I didn't do either one of those fucking things, sir. So
Okay.
your charges and your officers is fucking outrageous.
Mr. Belvoir, if you keep talking like that, I'm going to send you in the back, no bail, and we're going to come back to you tomorrow.
All I was doing was trespassing at fucking YMCA.
Mr. Belvoir, one more time, you use an obscenity in this courtroom, and I'm going to put you in the back. You're not going to get out of jail.
That's what they did last night, sir.
Okay, just
I
listen.
want my lawyer present right now.
Okay, just listen.
Desmond Cloaky, I'm not going to listen to you with a bunch of fake charges.
Okay, just take it easy. Okay, calm down.
Okay, go ahead. Read off the fake charges, sir.
All right, so the charges are resisting arrest and disorderly conduct.
They're both lies.
Okay, so, and this involves them contacting you
This
apparently
dude's loving up to hurt me more.
at the YMCA. The
They came from around the corner at the YMCA and I didn't say nothing to them, did disorderly nothing, and smashed me onto the ground and fucking hurt me this morning for no reason.
The maximum penalty for this is 90 days in jail and fines and cost of $2,050. Do you understand what you're charged with? I'm not saying you're guilty, but do you understand what you're charged with?
Yes, sir.
Okay, so you have certain rights that apply anytime you're charged with a crime. I'm going to read you your rights. It's going to take a minute.
Well, I got the right. Okay, go ahead.
You have the right to be represented by a lawyer, and if you can't afford a lawyer, I can appoint one for you. You're presumed innocent of all the charges until they're proven beyond a reasonable doubt. You have the right to a speedy and public trial. You have the right to a trial by jury unless you give that right up. You have the right to see, hear, and question all witnesses who testify against you. The right to call witnesses on your own behalf. You can have them appear at no expense to you. You have the right to testify on your own behalf or to remain silent. If you feel you can't have a fair trial because of the prejudice of a particular judge, you have the right to ask for a different judge. You have the right to appeal from any.
I can do that now.
You have the right to appeal from any time you're guilty following a trial by judge or jury. If you plead guilty, you give up all these rights, and if you're not a citizen of the United States, a conviction of a crime may result in deportation or exclusion from admission to the United States or denial of naturalization. Do you understand your rights?
Yes, sir.
It looks like you already have a lawyer. It's the Grimm Law Group. Mr. Balaban, do you already represent Mr. Belmar?
Yes, Your Honor, in his other cases.
All right, I find probable cause for the charges. Do you want to enter not guilty, please, on his behalf then, Mr. Balaban?
Yes, Your Honor, said not guilty, plead not guilty.
All right, we're going to enter not guilty pleas for you, Mr. Belvoir. So right now you're presumed innocent of these charges. And now we're going to talk about release and conditions and set some dates for coming back. Mr. Schuman.
The city's recommending $1,000 bail. The problem is he's got 4 other pending cases in Longview from between July and today. And he was presumably released on recognizance on those cases on condition that he stay out of trouble.
Yes, sir. Excuse me. That $1,000 bill in your court and your system is fucking a kangaroo court. Excuse my language. But listen to me, sir. Last time I was detained for felony harassment for 3 fucking days. I was denied the ability to use the phone at all.
No, warrior.
And I was released. And sir, look, I'd like to change judges or whatever the hell. This guy is biased against me. And if you guys keep me in jail for something I did not do, the police assaulted me. 9 fucking officers assaulted me at the AM/PM after I was walking away peacefully. They came back around the corner. Hey, go ahead.
Do you want to talk about bail? Mr. Balaban.
Yes, Your Honor. He does have several cases pending. He does have
We're on Zoom court on the 24th of this month.
I believe you have Zoom court for a pre-trial on the 6th. In his other cases, I just suggest we set for a pre-trial at this point.
Yeah, when I got out of jail, sir, on the 6th for a bogus charge, they let me go for what was it? I'm trying to tell you what happened at Walmart. They detained me for 3 days and then they let me go with nothing. Okay, on the 6th of what? And then the month before that, when I was supposed to be at my AP appointment, just let me speak to my lawyer, because last night they would not let me speak to him when I fucking got here. For 9 hours. I have an attorney and a lawyer.
Pre-trial, Madam Clerk.
4:30 in the morning.
10 o'clock on the 6th. That's when he said.
Yeah. 10 a.m.
All right, I'm going to set the pretrial on October 6th at 10 a.m. Mr. Belvoir, your behavior convinces me that you need to stay in jail. You just.
Sir, I would like to make you not my judge. Can I put this on the 24th with the same judge exactly that I already have? And my behavior in court, guess what? See, I got my ass whooped by your little bitch ass officers.
Okay.
I'm switching this. I have the right to switch.
The bail is $2,000 cash, $2,000.
No, you're not giving me any bail. I'm
Okay.
switching this to the other judge on the 24th with the court, sir.
October 6th. That's all.
Listen to me. I have the right to change my fucking judge. You guys hold me in jail, you will be found, Mr. Zoom, sir. Yeah, this is the officer right here last night that fucking hurt me. You know what? You guys are all fucking pieces of shit fucking interview. I'm switching that to the other judge. You're not gonna let me switch the judge? I have the right to do that, Mason. Fucking shit. Tell me you fucking everything.
Okay, did I need something else?
No, yeah, that.
Huh? Okay, we're done. Thank you.
People of the State of Michigan versus Reginald Matthew Tucson, case number 22F5-5110. Good morning.
Good morning, Your Honor. Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Kenneth Overwater, Assistant Public Defender on behalf of Mr. Tucson. I apologize. I was in Judge Frushauer's Zoom room because the matters I had there were going to be quick, but that docket still hasn't started.
Thank you. Okay. Well, my understanding is we have a preliminary examination scheduled this morning, and are the parties ready to proceed?
Judge, I would be helpful if I had a moment to talk to Ms. Kirby, but I believe we will be ready to proceed.
Thank you. Well, I think you're all I've got left right now, so I'll give you that chance. Maybe you guys could do it by cell phone, or I could put you in a...
Cell phone's fine, Judge.
Okay. Thank you. Be sure to mute your screens, is all I'll say.
Yes, sir. Thank you.
You're welcome, especially if you're going to talk about me.
Only in glowing terms, Judge.
Right. Okay, I see counsel is back. We will go back on the record. People of the State of Michigan versus Reginald Matthew Tucson. Case number 22F5-5110. Good morning.
Good morning.
How many witnesses do you intend to call?
Are we running the exam, Mr. Overwater?
I would need about 10 seconds to talk to Mr. Tucson to be sure of that, but I believe so. I'm sorry to delay the court. I did speak with him last night, but...
Could you put them in a breakout room real quickly, please?
Thank you, Your Honor.
If we are running the exam, Your Honor, it is going to be 2 to 3 witnesses. I believe only 2.
Okay, well, it will be important to know for sequestration purposes.
The officers are together at the Ann Arbor Police Department, so they would have to go into separate rooms themselves. And then the other, the victim, Mr. Lang, is on a Zoom by himself.
Yes. Okay, everybody's back now. We'll go back on the record. People versus Tucson, 22F5-5110. Are we ready to proceed?
Your Honor, my client indicated he wishes to waive his right to a preliminary examination this morning and proceed to circuit court to resolve the matter there. I would just note for the record, at an earlier PCC, defense demanded video from the incident at Kroger. That video was tendered to our office, but because of some technical difficulties, I wasn't able to review it last night. We were able to resolve those difficulties this morning. I have had the opportunity to review the video and discuss it with Mr. Tucson, and based on everything that we now know, it's his intent to waive his right to examination and proceed to circuit court.
Ms. Kirby, do the people waive their right to a preliminary examination?
Yes, Your Honor.
Thank you. I don't have your client here to get a written waiver, so Mr. Overwater, if there's no objection, I'd like to address him directly to make sure this is what he wants to do.
No objection. Thank you, Your Honor.
Thank you. Good morning, Mr. Tucson. Do you understand that you have the right to a hearing that's called a preliminary examination?
Yes, sir.
And if you held that hearing, the prosecuting attorney would be required to show that there's probable cause to believe that you're the person who committed the crime that you've been charged with?
Yes, I understand.
And in fact, I see they have 3 witnesses here this morning. It appears 2 police officers from the Ann Arbor Police Department, as well as what I assume to be a civilian witness. And they were here and ready to testify, but you would like to waive your right and go straight to circuit court. Is that correct?
Yes, that's correct, Your Honor.
Court will find that the waiver in this matter was knowing, understanding, and intelligent. Furthermore, the court will find that the prosecuting attorney, having waived her right to preliminary examination, the examination is waived. Mr. Overwater, do you acknowledge receipt of the information in this matter?
I do, Your Honor. I'd waive formal reading. My client would stand mute.
Court will enter a plea of not guilty on your client's behalf. This matter is going to be assigned to Judge Darlene O'Brien. So we will schedule a video conference arraignment November the 17th, 2022 at 1:30. Bond in this matter was previously established at $10,000 cash or surety. Does either side wish to address bond?
Yes, Your Honor.
You may.
Your Honor, the facts of the case make it very, very clear that my client was in the midst of a psychological or psychiatric episode at the time of the offense. There are things that he said to the officers that were highly delusional. And while these are violent offenses, the factual allegations of the resisting are relatively mild. It's an arm grab, standing and kind of looming a bit and sitting back down while at the hospital. Obviously, those allegations, if proven true, are sufficient to establish the facts of those charges, but they're, relatively speaking, milder in nature. As far as the felonious assault is concerned, the complaining witness in the case would have testified that he did not actually see the weapon, just believed him to have one in the based on the things that he had said, which were violent allegedly in nature. But another witness who was present at the Kroger reported to police that while my client was holding a pocket knife, that pocket knife was closed. So the blade was not extended. And while that also may reach the level of satisfying the elements of the offense, it is as well a very muted and mitigated set of facts to establish those offenses. My client is currently receiving medication. He has provided me with his contact information. He has a 1-year lease on an apartment on Greenbrier in Ann Arbor. He has family in the area and strong community ties. He has a 7-year-old son. He collects SSI for physical and mental disabilities. It's his hope that he will be able to raise bond to be released so that he can keep his apartment and keep his place to live, because the eventual resolution of this case is going to involve Mr. Tucson engaging with community mental health and maintaining his mental health treatment. That's the cause of these incidents, and that's the only thing that's going to prevent them from happening. And if he is rendered homeless, that will be counterproductive. So I would ask the court to consider at the very least reducing his bond to $10,000, 10%. He does have another bond on a misdemeanor matter that's set at $10,000, 10%. So he would need to raise $2,000, but he believes between his SSI and the help of family, he can do that. That would be sufficient to secure his appearance in court, and he would be willing to comply with whatever conditions the court set, particularly that he comply with any recommendations or treatment through CMH.
Thank you. And could you, Ms. Kirby, could you tell me anything you know about the defendant's past criminal history and what his status was on the date of this offense?
Yes, Your Honor. So I would just say, while he did make the threats, and yes, the pocket knife was not open, the threats contained that he was going to commit genocide after he gets out of jail. He told the officers that he was going to find their family and murder them in front of them. He said he would kill Ann Arbor police officers when he was released from jail, and he would return to Kroger and mess with the gas line so the place would blow up. He also made many threats stating that he would rape and commit sexual acts on the officers as well as their family and their children. And then while at the hospital receiving the treatment, he was seated into a chair. He said he was going to break the chair arm off and then stab it into one of the officers' neck. The FA threat to the Kroger employee, he said, "You're lucky I do not stab you right now. I should stab you in the back. I will stab you right into your neck." And the threats continued all the way until he was lodged at the jail, saying things that continued on to the threats, and then using both hands to attempt to hit at the officers while he was in their custody. As far as his criminal history, he has some theft, prior retail fraud. He also has some controlled substances charges, some of those dating back into the 1994-95 range, and then the controlled substances cases being as 2007.
Court's going to find that the bond currently established is the proper bond to ensure the public safety of the community. Clearly, there's probably something organic going on with Mr. Tucson, but the threats are so dangerous. And in an area that, let's be honest about it, people walk on eggshells anyway. I shop at that Kroger, and I know when you pull in after dark and you see all the signs about the video cameras and about how the whole place has to be videoed now for anybody who wants to go shopping there. It's an area for soft targets. And so for him to say he'll be going back there is very troubling to me. To have issued the threats to the officers is very troubling to me. It's not part of their job, as is assumed by, I'm not saying anybody here makes that assumption, but some people assume the cops, that just goes with the job. That's part of their hourly rate. It is not to have any hands placed on them or to have these types of threats made against them or their family. So I find all of that deeply concerning. We'll keep the bond at $10,000 cash assured. And he did get an in custody date, which is November 17th, 2022 at 1:30 before Judge O'Brien. So thank you all very much.
Thank you, Your Honor. Mr. Tucson, give me a call from the jail, okay?
Am I able to say something? Because I was released and none of that
Don't
happened.
say anything right now.
That happened when I was released.
Mr. Tucson, it's not going to help. Give me a call from the jail, okay?
Yes, sir.
Thank you all very much. Have a good day.
Thank you, Judge. Have a wonderful day.
Nothing even
Thank
happened when I was released. So I'm back in custody in over a month. None of that happened. Wow. They can kill black people.
Two courtrooms, different people, same system. Anger becomes guilt, mental illness becomes a threat, and bail becomes a tool of pressure instead of protection. This isn't about defending behavior, it's about asking whether justice only works for those who stay silent and compliant.